In the world of family law, few cases reveal the true complexity of human relationships quite like the ones we're about to explore. These are stories of broken promises, fractured families, and the painful aftermath of relationships that didn't survive the test of time. What unfolds in these courtrooms isn't just about money or possessions. It's about the deep emotional wounds left behind when love turns to resentment, and when the people who once planned a future together become adversaries fighting over the remnants of what they once shared. Our first case brings us to a courtroom where 33-year-old construction supervisor Mark Hovey stands before the judge with a singular demand. He wants back an engagement ring he gave to 31-year-old Jacqueline Casals, the mother of his 4-year-old daughter. But as is often the case in matters of the heart, nothing here is straightforward. Jacqueline claims the ring wasn't an engagement ring at all. According to her testimony, it was a Mother's Day gift purchased on that very holiday and presented alongside a Mother's Day card. The story begins 2 years before this courtroom encounter. Mark and Jacqueline had a child together, a daughter who was now 4 years old. Despite having a child, they had never married. 2 years prior to the current case, Mark decided to propose. He gave Jacqueline what he considered an engagement ring. However, their relationship was turbulent from the start. Mark himself admits that even when he purchased the ring, their relationship was unstable. He describes it as going up and down constantly. When asked why he bought the ring if things were so uncertain, Mark explains that Jacqueline had been troubled by the fact that he had never given her an engagement ring. She wanted some kind of commitment, some assurance that they would actually be together. The ring, he hoped, would provide that reassurance. But Jacqueline tells a different version of events. She insists they purchased the ring together on Mother's Day. Her son and daughter were both present during the shopping trip. They also bought Mother's Day presents for Mark's mother at the same time. After the purchase, they went to Mark's grandmother's house to deliver the gifts, and Jacqueline showed everyone the ring, presenting it as her Mother's Day present. She emphasizes that Mark never actually proposed. There was no moment where he asked her to marry him or explicitly called it an engagement ring. The situation took a dramatic turn just 17 days after Mark gave Jacqueline the ring. A man arrived at Jacqueline's workplace to serve her with paternity papers. Mark was taking legal action to establish that he was the father of their daughter. When Jacqueline received these papers, she called Mark immediately. She explained that she had no money to hire a lawyer to represent herself in court. The only item of value she possessed was the ring. She made a decision that would become the central point of this lawsuit. She took the ring back to the store and returned it for the money, using those funds to pay for legal representation. Mark knew about this almost immediately. He was aware 2 years ago that Jacqueline had returned the ring and converted it to cash. Yet he did nothing. He didn't file a lawsuit, didn't demand the money back, didn't take any legal action whatsoever. For 2 full years, he remained silent on the matter. So what changed? What brought him to court after all this time? The answer lies in the ongoing custody battle between these two parents. Mark explains that his statute of limitations was approaching. He had until October to take action, and he finally decided to move forward. But the timing wasn't coincidental. Mark and Jacqueline were still entangled in civil court proceedings regarding their daughter. Mark claims that Jacqueline is in contempt of court because she doesn't allow him to see their daughter according to the court-ordered visitation schedule. The current arrangement gives Mark visitation on Tuesdays and Thursdays from 5 o'clock to 8 o'clock in the evening. He also gets their daughter from noon on Saturday until noon on Sunday. Despite this clear schedule, Mark insists that Jacqueline sometimes simply refuses to let him take their daughter. He says he files a police report every single time this happens. Jacqueline, however, has her own perspective on the visitation problems. According to the court papers, Mark is supposed to pick up their daughter by 5 o'clock. He has a 15-minute grace period. If he's more than 15 minutes late, he loses that visitation period. Jacqueline explains that this rule was implemented because, in the beginning, Mark was supposed to arrive at 5 but would sometimes not show up until 7:30 in the evening. When he finally arrived, he would expect to start his full visitation period from that late hour. When Jacqueline confronted him about his chronic lateness, asking why he couldn't arrive on time, his response was dismissive. According to Jacqueline, he told her that she had no life and nothing else to do, so she could just sit there and wait for him. Whether this was meant sarcastically or not, it hurt. It demonstrated a lack of respect for her time and her life. That's when she insisted on having the 15-minute rule written into their court order. The judge listening to this case has heard similar stories countless times before. She recognizes the patterns immediately. Two people who made a child together before they were ready to commit to each other. A father who, to his credit, wants to be involved in his daughter's life and has pursued visitation from the very beginning. A mother who is supposed to facilitate that relationship but sometimes makes it more difficult than it needs to be. And underneath it all, the festering resentment that comes from a failed relationship. Mark is remarried. His new wife Dahlia Hovey is present in the courtroom, and this new marriage has added another layer of complexity to an already complicated situation. Jacqueline points out that Mark and his current wife got together very quickly after their separation. According to Jacqueline, she and Mark were still seeing each other just 2 days before Mark went on his first date with Dahlia. A week after that first date, Dahlia moved in with Mark. 2 months later, they were married. If Mark truly considered the ring he gave Jacqueline to be an engagement ring, Jacqueline questions, why was he married to someone else so quickly? But the situation becomes even more complicated when other children enter the picture. Jacqueline has a son from a previous relationship. During the time when Mark and Jacqueline were together, Mark had taken on a father role for this boy. He was raising him as his own. When Mark and Jacqueline separated, the boy continued to visit Mark along with his half-sister. They would go together for overnight visits, and everything seemed to work well. But then, according to Jacqueline, things changed when Dahlia came into the picture. Jacqueline claims that Dahlia didn't want her son to be part of their new family. The children were split up. If they were going to visit, only Jacqueline's daughter was allowed to go. Her son was left out, excluded from the family unit he had known. Mark disputes some of this, saying that Jacqueline was inconsistent about allowing the boy to visit. Sometimes she would let him come, sometimes she wouldn't. Eventually, Mark decided it was better for the boy not to come at all because the inconsistency wasn't good for him. But Jacqueline insists that Mark told her directly that Dahlia didn't want her son at the house. She explains that every time she and Mark were arguing, her son would go to their house and wouldn't be pleasant to Dahlia because he felt protective of his mother. Even now, years later, the situation remains difficult. The boy still calls Mark Dad. He thinks of Mark as his father. But according to Jacqueline, Mark no longer responds to him in that way because of his new wife's influence. Dahlia Hovey has her own version of events. She testifies that when Jacqueline's son would come to their house, he arrived with instructions from his mother. According to Dahlia, Jacqueline told both children not to eat her food, not to talk to her, not to touch her, not to kiss her, not even to look at her. Dahlia says she cooks every night for her family, but the children would refuse to eat because their mother had forbidden it. She knows this, she claims, because the children told them directly. Her stepdaughter would say that her mom said she couldn't eat Dahlia's food. Dahlia describes how the little girl, who initially would hug and kiss her when they first met, suddenly stopped showing any affection. From one day to the next, the child's behavior completely changed. Dahlia insists she loves this daughter dearly, and the girl loved her at first. But now, because of what her mother told her, the child no longer hugs or kisses her. She only talks to Dahlia in a normal way because that's all she's allowed to do. Jacqueline flatly denies these accusations, calling them lies, but the judge has seen enough of these situations to recognize that there are likely elements of truth on both sides. The reality, as the judge points out, is that children are always the ones who suffer in these situations. A 4-year-old girl should have a father in her life. She's fortunate that Mark wants to be involved, that he pays his child support of $579 per month, that he pursues visitation and wants to maintain a relationship with his daughter. That's something to be protected, not undermined. The judge turns her attention to Jacqueline, reminding her that she's not supposed to interfere with her daughter's relationship with her father. She's supposed to put aside whatever negative feelings she has about Mark and his new marriage for the good of her child. She has 2 children, including the young man present in the courtroom, and she's supposed to make things easier for everyone, not harder. But the judge also turns to Mark, acknowledging that there's probably some truth to Jacqueline's claims about inappropriate remarks. Mark admits he has made some hurtful comments, though he denies the specific one about Jacqueline having no life. The judge reminds him that he's supposed to show nothing but respect for Jacqueline because, even if they don't love each other anymore, she's still the mother of his child. As the judge considers Mark's demand for the return of the engagement ring or its monetary value, she finds herself unsympathetic to his case. There are several reasons for this. First and foremost, he waited 2 years to pursue this matter. He knew immediately that Jacqueline had returned the ring. He did nothing about it for 24 months. He sat on his rights and took no action. The only thing that motivated him to finally file this lawsuit was the other ongoing legal battle about custody and visitation. The judge sees this lawsuit not as a legitimate attempt to recover property, but as another weapon in their ongoing conflict. She believes that pursuing this case will only make their already difficult situation worse. But before the judge can deliver her final ruling, Jacqueline brings up another issue. She says that when her daughter comes home from visits with Mark, she sometimes has bruises. She's not properly groomed. And most seriously, there was an incident involving a hockey stick. Jacqueline claims that Mark hit their daughter with a hockey stick while she was at his house. She says he admitted to it. The police were called. Child services became involved. Court papers were filed. The judge pauses, needing to understand exactly what happened. She asks Jacqueline to describe the bruise. It was, according to both Jacqueline and the doctor who examined the child, about the size of a silver dollar or a half-dollar. It was a black and blue mark. When the child came home crying and told her mother that her dad had hit her with a hockey stick, Jacqueline took her to the doctor. The doctor, upon seeing the bruise, felt obligated to report it. Medical professionals are required by law to report suspected child mistreatment, and the doctor couldn't let it pass. Mark's version of the incident is somewhat different. He admits he hit his daughter, but he characterizes it differently. They were playing together, he explains. His daughter hit him in the back of the head with a hockey stick. He grabbed the stick from her and tapped her on the side, essentially demonstrating the action of hitting her back. He insists it wasn't even really a bruise, but if it did bruise, he takes full responsibility. The incident was investigated by the authorities, and the case was closed. Mark still has his visitation, which suggests that the investigators didn't find evidence of intentional harm or ongoing danger. The judge acknowledges that what Mark did wasn't smart. Hitting a child with a hockey stick even lightly, even in response to being hit himself, wasn't the right choice. But she also questions Jacqueline's decision to take the child to a doctor for a bruise the size of a silver dollar. The judge suggests that Jacqueline didn't take the child to the doctor out of genuine concern for her welfare, or because she thought the child was seriously injured. Instead, she took her there to document the incident, knowing full well that the doctor would be required to report it to Child Protective Services. Jacqueline admits this openly. She says she would do it again. If it happens again, she'll take the same action. The judge explains to Jacqueline that what she's doing is actually hurting her child. She provides an analogy. If the situation were reversed, if their daughter were about to cross the street and Jacqueline grabbed her by the arm to pull her back from oncoming traffic, she might accidentally dislocate the child's arm. If this happened during a time when Mark had the child and he discovered the injury, he could take the child to the doctor and report Jacqueline for causing harm. But the judge suspects that if the roles were truly reversed, if Jacqueline had accidentally injured their daughter while trying to protect her and Mark had a reasonable explanation, he wouldn't rush the child for emergency treatment over a minor injury. The only reason this escalated the way it did is because Mark and Jacqueline are no longer together. That's the root of the problem. The judge warns Jacqueline that she can engage in this kind of behavior to such an extent that Mark will eventually decide it's not worth the trouble. The constant conflict, the police reports, the investigations, the documentation of every minor incident could become so overwhelming that he might step back from his daughter's life entirely. And maybe, the judge suggests, that's exactly what Jacqueline wants. Maybe she wants to be able to tell their daughter that her father is terrible and doesn't want to see her. Jacqueline denies this, but the judge isn't convinced. She tells Jacqueline that she has what's called a passive-aggressive personality. The child won't learn on her own that her father is inadequate unless her mother teaches her that lesson. It's a mistake for a child to grow up thinking their father doesn't care. If Jacqueline succeeds in creating that impression, she might enjoy her daughter's devotion in the short term. But as the child grows older and develops her own perspective, she may come to resent her mother for poisoning her relationship with her father. The choice, the judge emphasizes, is Jacqueline's to make. Finally, the judge delivers her ruling on the engagement ring. She refuses to make the situation worse by ordering Jacqueline to pay Mark money for the ring. His lawsuit is dismissed. Mark seems to understand and accept this decision. But just as the proceedings seem to be wrapping up, Jacqueline mentions that she had filed a countersuit. She wants 2 quilts returned that belong to her children. Mark was supposed to bring them to court today, but didn't. One is a Tweety Bird blanket that Mark's new baby has been using. When Jacqueline saw the baby with it recently, she asked Mark if she could have it back when he was done with it. Mark agreed and told her she could have it back. The other is a quilted blanket purchased at an auction, paid for with Jacqueline's credit card. It has her son's handprint on it, and she intends to give it to him. Mark agrees to return both items as soon as possible within a couple of days. With that matter resolved, the first case concludes. The second case that comes before the court involves a very different set of circumstances, but similar themes of failed relationships and disputed debts. Kathleen Sumner, who works as a college facilities coordinator, is suing Roosevelt Keyes, a nurse. She claims he owes her for loans she made to him, for medical bills, and for emotional distress caused by a false report he made to Child Protective Services. Their relationship was brief, lasting only about 6 or 7 months, but its aftermath has been contentious and painful. Kathleen met Roosevelt in May of 1997. During their short relationship, he borrowed money from her on multiple occasions. The first loan was for $300, given to him in cash on June 11th. Between June and July, he borrowed an additional $200, then another $100. Kathleen has documentation for these loans, including a canceled check dated July 8th for $200 and 2 separate cash withdrawals of $300 from her credit card account. Roosevelt had asked for cash because several of his checks had bounced. In total, according to Kathleen's records, Roosevelt borrowed $600 from her. When asked if any of this sounds familiar, Roosevelt admits that some of it does. He confirms that on June 11th, he asked Kathleen for $300 and she gave it to him. He acknowledges the $200 check from July 8th. He remembers one cash loan of $100. So far, he agrees that the total is $600. But here's where their stories diverge dramatically. Roosevelt claims he paid Kathleen back. He says he returned the money in cash when he came back from annual training. Kathleen flatly denies this. She says he never returned a single dollar. Roosevelt tries to explain the nature of their relationship. He says they had fallen in love. They had made promises to each other about their relationship. They were functioning as a family. She had his ATM card. They would pass cash back and forth between them. He never thought to ask for a receipt or any kind of documentation because they were in a relationship of trust. But when the judge asked to see his bank statements or ATM records proving he withdrew cash to repay her, Roosevelt admits he doesn't have them with him. He didn't bring them to court. Kathleen's position is simple and clear. He never returned the money, and she has no record of any repayment. But the loan money isn't the only issue. Kathleen is also suing for $3,000 in pain and suffering, and this is where the case takes a darker turn. Roosevelt had been staying with Kathleen almost immediately after they met in June of the previous year. Throughout the course of their relationship, by around December, Kathleen asked him to leave her house. She tried her best to tell him that she was no longer interested in continuing the relationship. What followed, according to Kathleen, was a campaign of harassment. Roosevelt made volatile phone calls to her home. He left notes and messages on her mailbox. One note in particular reveals the threatening tone of his communications. The note, which Roosevelt admits to writing, reads in part, "Like I say, Kathy, if we go in front of one judge, I guarantee you will go in front of another. I have nothing to hide. You'll be the one explaining why you painted your house last summer." The judge tries to understand what this means. Roosevelt explains that Kathleen was demanding he pay back the money he owed her, and he was insisting that he didn't owe her anything because they had been passing money back and forth throughout their whole relationship. But that one sentence about explaining why she painted her house seems to hint at something more. The judge presses further, and the truth begins to emerge. Roosevelt eventually admits that at some point after he left Kathleen's home, he made a report to the San Mateo Police Department. He didn't contact Child Protective Services directly, but he knew that when he made his report to the police, they would be obligated to involve child protection authorities. His report concerned one of Kathleen's children, specifically her oldest daughter, who was 9 years old at the time and is now 10. Roosevelt explains his reasoning for making the report. Throughout the course of their relationship, while he was living in Kathleen's home and helping to watch her children, he noticed concerning behavior from the oldest daughter. The girl was afraid to go to the bathroom by herself. She was afraid to take a shower alone. She wouldn't go into her bedroom without an adult standing just outside. When they got into the car, she wanted to sit in the middle between her 2 younger sisters. Roosevelt found this behavior very strange for a 9 or 10-year-old child. He claims he brought his concerns to Kathleen's attention on several occasions, though Kathleen emphatically denies that he ever discussed any concerns about her children with her. According to Kathleen's account, the timing of Roosevelt's report to the police was not coincidental. She had called him in April and given him an ultimatum. He had until May 1st to make a substantial payment toward the debt he owed her. If he didn't pay, she would take him to small claims court to collect the money. After she made that phone call, she was subjected to what she describes as an onslaught of threatening phone calls and letters. The messages were clear. If she took him to court over the money, he would jeopardize the custody of her children. He would tell authorities what he claimed to know. One message explicitly stated, "Don't push me, I will. We go in front of one judge, we'll go in front of another." The judge examines the letters Roosevelt sent, and certain things become very clear. First, it's obvious from Roosevelt's own writing that he acknowledges owing Kathleen money. Second, and more troubling, one letter contains the statement, "It's only money I owe you, but I guarantee you will have to prove yourself a worthy parent." This creates a direct connection in writing between Kathleen's pursuit of the money he owes her and his threat to report her to child protection authorities. The implication is unmistakable. If she drops the money claim, he won't make the report. If she pursues the debt, he'll use what he knows about her children as leverage. The judge asks a critical question. Roosevelt and Kathleen separated in January. Roosevelt made his report to the police in May. What happened between January and May that suddenly inspired him to make this report? If he genuinely had concerns about the welfare of Kathleen's daughter, why did he wait 4 months after leaving the home to report it? Roosevelt's answer is evasive and confusing. He claims he spoke to Kathleen on several occasions about his concerns, both before and after he left. He mentions that they went out on a date on February 13th. He insists they had conversations about the child after January, but he struggles to provide specific details about when these conversations occurred or what was said. The judge becomes increasingly frustrated with Roosevelt's vague and circular responses. She asks him directly if he's on any kind of medication, noting that he seems to be dancing around her questions. Roosevelt denies being on medication and apologizes for his unclear answers. The judge makes it plain that she knows the difference between genuine concern and manipulation. She tells him that while she doesn't doubt he may have had some questions about the welfare of Kathleen's child, her real question is about his motivation for reporting it when he did, and that question seems to be answered by his own handwritten threats. When Roosevelt made his report to the police, the authorities followed proper protocol. The police department called Kathleen first to inform her that a report of child molestation had been made against her oldest daughter, Carmel. They had already gone to the girls' school, pulled her out of class, and interviewed her. As required by law, they also reported the matter to Child Protective Services. But after interviewing Kathleen, interviewing Carmel separately, and reviewing all the available information, the case was closed at intake. The social worker's investigative narrative states that the information was unfounded. Kathleen has the documentation to prove this. But Roosevelt introduces another element to the story. He mentions that Kathleen has a sister who lives right behind her house, and that there was some kind of incident involving this sister that resulted in legal action. According to Roosevelt, he went to the sister's house in his underwear and engaged in behavior that the sister found threatening. She called the police and obtained a restraining order against him. The judge decides this claim needs to be investigated immediately. She calls Kathleen's sister on the telephone right there in the courtroom. The sister confirms that there was indeed an incident approximately a year ago. She did obtain a protective order restraining Roosevelt and requiring him to stay away. She describes what happened during that incident. She told her sister about it immediately, before she even called the police. The restraining order was in effect, and Roosevelt has stayed away since then. She hasn't had any difficulty with him after that initial incident. After hanging up with the sister, the judge turns back to the parties before her. The sister's testimony confirms Roosevelt's account of that particular incident. She even confirms that the incident occurred while there was supposed to be a restraining order in place protecting both Kathleen and her children, though Kathleen claims the restraining order was never actually in effect because Roosevelt was never properly served with the papers. The judge has heard enough. She's not going to spend any more time on this case. Her ruling is clear and direct. Roosevelt owes Kathleen $600, and he must pay it. However, the judge is not making any award for pain and suffering. She's not entirely convinced that Kathleen shouldn't be following up on some of the concerns that were raised, regardless of Roosevelt's motivations for raising them. The judge indicates that she intends to find out whether Child Protective Services had all the facts before they mark the case as unfounded. And with that, the second case concludes. Two very different disputes, but both rooted in the same fundamental problems. Relationships that fell apart. Money that became a weapon. Children caught in the middle. trust that turned to suspicion, and two people who once cared for each other reduced to adversaries in a courtroom, fighting over money and accusations, each convinced of their own righteousness and the other's wrongdoing. These cases reveal the messy reality of human relationships when they fail. There are rarely clear heroes or villains. Instead, there are two people who made choices, some good and some bad, who hurt each other in various ways, and who now find themselves before a judge trying to sort out the wreckage. The legal system can order someone to pay money. It can enforce visitation schedules. It can investigate reports of harm to children. But it cannot heal the underlying wounds. It cannot restore trust. It cannot make two people who have learned to hate each other suddenly treat each other with respect and kindness. In the first case, a father wants to see his daughter, and a mother wants to protect her. Both goals are valid, but the execution has become toxic. The engagement ring that started the lawsuit is almost irrelevant. It's a symbol of a failed promise, of expectations that weren't met, of a relationship that looked like it might become a marriage but instead became a custody battle. The real issue isn't whether the ring was an engagement ring or a Mother's Day present. The real issue is whether two parents can find a way to co-parent their child without turning every interaction into a battle. In the second case, a woman loaned money to a man she loved, and he apparently never paid her back. When she tried to collect the debt, he threatened to weaponize her children against her. Whether his concerns about her daughter were genuine or fabricated, the timing of his report to authorities, coming immediately after her demand for repayment, reveals his true motivation. The $600 he owes her is a small amount compared to the damage he attempted to cause by involving child protection services in her life. These are the kinds of cases that fill family courts every day across the country. Behind each case file, behind each docket number, there are real people with real pain, real anger, and real consequences that will follow them long after the judge's gavel falls. The legal system does its best to find fair solutions, to protect children, to enforce agreements, and to hold people accountable for their actions. But at the end of the day, the judge can only do so much. The real work of healing, of moving forward, of putting the needs of children first, that work has to be done by the people themselves. And sometimes, as these cases show, that's the hardest work of all.